trouble with the chair.
Okay.
Good morning. May it please the court? My name is Marty Smith with the firm of Bond, Arnett, Phelan, Smith & Craigs in Ocala. I'd like to reserve 3 minutes of my time for rebuttal.
Got it.
Before I start, I'd also like to introduce my summer intern, Tyree Boyer. Now, you can say what my partner said when he introduced. That's not Tyree Boyer, but this is the third.
I thought so.
Third.
Yeah,
His grandfather and uncle both share the name.
well, I knew his grandfather quite well.
I know his uncle quite well.
His grandfather has entrusted him to me. He's intending to go to law school, and I'm not supposed to mess that up.
Okay.
So,
What's he thinking, for God's sake?
this morning I'm representing the appellants in this case, Larry and Rebecca Coleman and their son William Coleman, defendants in the trial below. And this appeal arises out of a dispute over a driveway. To give you briefly the history of the property, the parties, the Colemans and Mr. Evans, own adjacent property on a peninsula that juts out into the Rainbow River in Dunellen, what we call Blue Run. This property, back prior to 1988, all belonged to a gentleman named Schmutz. He owned the peninsula where he had his house, the house out on the point of the peninsula. He owned what was referred to in the record as a gazebo or boathouse next to that, also on the peninsula, and a residential lot in Blue Cove subdivision that adjoined.
We call
that.
those gazebos down in...
I'm sorry, Your Honor?
We call them gazebos down in Gazebo.
This one is one that sits out of the water. It's pretty cool, okay? It'd be a great gazebo. In any event, in 1988, Mr. Evans entered into a contract with Mr. Schmutz to buy the Blue Cove subdivision lot. As part of his contract, he was to receive an easement to a driveway. In other words, there was a residential subdivision lot, and then the remainder of the peninsula was not part of the subdivision. It had a driveway that connected to a dedicated road in Blue Cove subdivision. Again, Mr. Evans in his contract was to receive an easement to that driveway. He did not, and he knowingly went forward with his closing without that, subject to being worked out later. His contract also called for, in addition to him getting an easement, to enter into a maintenance agreement over that road. After his closing, the attorney for Schmutz prepared an easement agreement with the maintenance agreement, sent it to him. They could never agree to terms. That was never executed. And so from 1988, when he purchased his property, he did not have legal access through that, even though he did tie his driveway into it. By the way, to his property, his residential lot abuts this driveway or this dedicated road in Blue Cove subdivision. In 1991, Schmutz sold first the gazebo part of the property to somebody that's not a party at this point to this litigation. And in that closing, and again, that's part of the peninsula, that was not part of the subdivision, did not include any kind of access or easement. So it was created, in effect, a landlocked parcel, serviced potentially only by water access to the Rainbow River. Shortly after that, my clients, the Colemans, bought the remainder. That is, they bought Schmutz's house on the point, along with fee title to this driveway that is at issue here. In their closing documents, their deed said subject to easements, if any, for ingress and egress for adjacent property. Did not identify anybody, and again, we've got the gazebo owners who are landlocked but for this driveway. What we're really talking about here and what this case was about is about 100 feet of driveway, more or less. That is, that part of the driveway from Mr. Evans' driveway into his house to the Coleman house. Now, the trial court did a great job in terms of really detailing out all of these facts. There is one fact that the trial court got incorrect that I wouldn't, if the court were so inclined to issue a written opinion, please don't say this in your opinion. The trial court said that the driveway goes all the way to the Rainbow River. That creates all kinds of violations. It doesn't. It goes to the back door of the Coleman's house. So please, you understand those river communities, and particularly this one, very pristine, very special river. It doesn't go all that way. The trial court then found, though, that first, Mr. Evans brought suit for an express easement, an implied easement, and a license. An express easement arising both out of his transaction in 1988 and an implied easement out of his 1988 transaction, and then an implied easement out of the Coleman's purchase of their property, and a license. The trial court, we think, correctly found that any claim for express easement or implied easement out of his 1988 claim was barred by the statute of limitations. That is, he had been on notice from 1988 forward that he did not have an easement, and he brought no case until 2007.
Now, does Evans have access without this easement?
Yes, Your Honor. Evans does have access he has over 100 feet of frontage on Blue Cove Drive, which is a dedicated road part of the subdivision. Immediately adjacent to that is where this driveway ties in. Now, he tied his driveway to his garage into this. The trial court here accepted, it's very interesting when you read the trial court's ruling, because while they found that Evans had an implied easement as a result of my client's purchase in 1991, which we're really going to address in this argument this morning, the trial court also found in the alternative, if the court were to overturn that he would have a license as to the first 50 feet, which would let him have access to that driveway. But to specifically answer your question, he has, I think, 105 feet on Blue Cove Road, or Blue Cove Drive.
But not where the driveway is?
But not where his driveway is. The court's alternate decision that we assert is the correct decision. We're saying that what Judge Lambert gave as an alternative is the correct ruling.
How long has Mr. Evans been using that driveway?
He constructed his house somewhere between 1988 and 1991 when my clients purchased the property, so 20
Some years.
Yeah, some years. And that's why we asserted, yes, that he had a license to use that portion of it, but not the remaining 100 plus feet. And that's really what this case is.
And the license would give him access to the driveway, but not to this parking pad that's also in front of his house? Is that correct?
Would give him access to his driveway. The parking pad, to be honest, I don't remember that part of it, but there's also a provision in there that would allow him to have a gate further past his house for emergency access that he would have to put in at his expense, but a lock gate to let him get to the rest of it. So he had limited use of portions of the remainder of that. In this appeal, we assert two separate issues. One, that Mr. Evans, contrary to the court's findings, was not an intended third-party beneficiary of the Coleman transaction. And secondly, that the statute of limitations that the court correctly applied to his express easement and implied easement claim in 1988 should also be applied to anything out of the 1991 transaction for the same reasons.
The judge found otherwise, correct? On the implied easement? In other words, he said
Correct.
He wasn't on notice till they cut it off.
So they put the fence up?
So they put the fence up.
Yes, and I'm going to address that.
Okay.
Hopefully in the second part of my argument. It's our position that the court erred in finding Evans to be an intended third-party beneficiary of the Coleman transaction. This court, in American Quicksign versus Reinhart and Judge Monica, I believe you were on that panel, Judge Savoya wrote a very detailed decision that really sets out, I think, the law of both express and implied easements as it relates to Florida. Several things out of that case, several statements of law that specifically apply here. One, an easement may be created by express grant, by implication, or by prescription. Here we're dealing with an easement by implication. But the court also said that documents that convey easements should be construed in the same manner as contracts. And if the documents are ambiguous, courts can look at extrinsic evidence to determine the intent of the parties at the time the document was executed. That is, both parties. And when construing ambiguous provision of a document that purport to create or convey an easement, a court must attempt to fulfill the intentions of the parties who executed it. Here again, the trial court did find that there was an implied easement arising out of this Coleman purchase in 1991, specifically this language of subject to easements, if any. However, it's our position that the trial court applied the wrong standard in doing that. Again, in the American Quicksign case, it says to look at the law of contracts. And so we specifically look to the law of third-party beneficiaries in contracts. Here, what the court said was that there was clear and convincing evidence that Schmutz, the grantor, intended to benefit Evans, and that Coleman, my client and the appellate in this case, was on notice as to Schmutz's intent. However, American Quicksign says the intent of the parties, that is, both parties. Here, even if Schmutz intended to benefit Evans, there's no evidence whatsoever in the record that shows that Coleman intended to benefit Evans, only that they were on notice. But more importantly, when we look at the law as it applies to third-party beneficiaries, the Esposito versus True Color Enterprises, which was a Florida 4th DCA case from 2010, specifically addresses this. In that case, it's dealing with a subcontractor suing on trying to sue as an intended third-party beneficiary to a contract between a general and a sub. But the court said there that a person who is not a party to a contract may not enforce its terms where that person receives only an incidental or consequential benefit from the contract, and then said a party is an intended third-party beneficiary of a contract only if both parties to the contract clearly express an intent to primarily and directly benefit the third party or class of persons. So that is, both parties have to express that intent, a clear expression of intent. Here the trial court again found that Coleman was only on notice, not that Coleman ever expressed any sort of intent to benefit Evans. In fact, the evidence was all to the contrary.
Well, wasn't there evidence from the original grantor who said that it was in fact his intention to create an easement?
No, Your Honor, there was not. Mr. Schmutz died long ago.
It was the guy after him. Who was the person after? Somebody testified that it was the intention to create an easement there.
The lawyer, right?
The lawyer testified that it was his opinion that that's what Schmutz intended, but that was not a testimony. But again, that's only one party, and maybe Mr. Schmutz did intend to do that. We simply, his lawyer thought 20 years later maybe that was the case. 20.
More than that.
Yeah.
How many ever? A long time ago. Yeah. But there was no testimony whatsoever as to Coleman's intent. And this Esposito case makes it clear that it's the intent of both parties. American Quicksign talks about the intent of parties, that is, both parties to the contract, not Mr. Evans' intent, but Mr. Coleman, the Coleman's intent. Secondly, too, it's our position that the court's ruling as to the statute of limitations should also be applied to the implied easement arising out of this 1991 transaction. The appellee makes the point that, there's no cause of action arises until there's an obstruction or prevention with an easement. What we assert is that this is a DEC action, declaratory judgment action that they brought, so that it really is when the plaintiff is in doubt as to their rights and privileges. We cite some cases that support that, but that's
can't
also...
the doubt arise because of the obstruction or the fence?
Here's the thing with the obstruction with the fence. The fence is on the sides of the easement. It's never been closed off. However, in the record, there was testimony by Mr. Evans. It's at page 58 of the trial transcript that in 1995 or 1996, the Colemans erected a gate across this driveway at Blue Cove Drive. That is, before it gets to his driveway into his house. They put a gate up there. At that time, he had a long hedge, a very high hedge that obstructed the the property so that people could not come and trespass, and that's what really led to this fencing issue. Doesn't have anything to do with the court's decision here, but in other words, that obstruction occurred in 1995 or 1996.
That cut him off, or he had continued?
If the gate was ever closed, it would. There's still no gate there, and there's still only a fence that runs along the sides of the driveway.
Okay, but he was never cut off.
He's never been cut off, and under the license, he still would not be cut off.
Right, so how would that create a doubt in his mind as to his easement?
The gate, in other words, the gate being put there should have created, if this fence creates a doubt, then the gate creates a doubt. And the gate was in 1995 or 1996, according to his own testimony. Moreover, in 1991, at the time of the Coleman closing, Mr. Trow testified and Mr. Evans testified that Mr. Trow called Mr. Evans. There's also testimony from other witnesses, from a realtor, as to the fact of him calling and talking about the fact that this easement agreement had never been entered into. Again, in 2000, Mr. Evans had another agreement prepared. He said it was a maintenance agreement, but he also said in his testimony that it was along the same lines as the agreement prepared by Mr. Trow, which is part of the record and which shows that this is that it was a maintenance and easement agreement. So, as of 2000, he still knew that there was an issue regarding the easement, and that's clear in the record. He did not bring this case until 2007. Also, on several occasions...
So is that a factual issue when he first had doubts about it?
It is a factual issue. However, it's whether those factual issues give rise under the statute of limitations to requisite notice.
Okay, but did the trial court, in ruling on the statute of limitations, in essence come to a factual conclusion as to when he was in doubt and therefore when the statute began to run?
It was a factual determination, but we think it is a factual determination not supported by, not in compliance with the law. Thank you, Your Honor.
So you don't think there's any evidence in the record that supports the factual finding of the judge on the statute of limitations issue?
First off, if the court were to apply what we consider to be the correct standard, and that is, when is the plaintiff in doubt as to their legal rights and privileges, then clearly the court said in 1988, in 1989, 1990, he was already in doubt. He was not a party to this 1991 transaction, but even then, the events after 1991 show that he was in doubt. One, this conversation with Mr. Trow in 1991. Two, the gate being erected in 1995 or 1996. Three, his own easement agreement, maintenance agreement that he prepared or had prepared in 2000. I'd like to reserve the remainder of my time for rebuttal. Thank you.
All right, you have exactly 2 minutes left. And we'll hear now from the appellee.
May it please the court, my name is Russ Lapierre from Ocala, from the law firm of Latwegians, Lapierre and Ayers, counsel for appellee. I'm going to just say that the obstacle that the appellants have on this appeal is that the trial court heard the evidence and determined the factual questions contrary to the appellant's viewpoint. And that applies to the statute of limitations. And first of all, the statute of limitations rule is that until the right is invaded, the statute of limitations does not begin. And then as applied to easements, and this court's case in the state of Johnston against TPE Hotels, Inc., the statute of limitations begins to run when the purported easement is barred or prevented.
Under the court's ruling as it now stands, does your client have any obligation to contribute to the maintenance of the road?
No. No.
Because one of the bases on which he claims there was an easement was this discussion about an agreement that was never finalized and put into writing where he would get an easement and he would pay to help maintain the road, right?
Well, he lost on that. That was in count one on the express easement, and we're not arguing that. That was something that was done before the Colemans purchased their property. So the The basis of the claim is the implied easement, and I'll come to that real quickly, but I just want to say real quickly that I think it's clear that the rule of law on statute of limitations is a bright, clear standard, and that is, once there's an invasion of the right, now I have to act. And if it were otherwise, it would give rise to all kinds of misunderstandings, lulling of the latches and statute of limitations passing. So let me
Can you
give it
explain the effect of the license versus the easement on this parking pad? I'm a little confused about the layout and what would happen in one version versus the other.
Okay, here's the main highway, and then what I call the historical paved roadway comes off that highway and comes up about 3/4 of the way into the property. And Mr. Evans, the appellee's home, is on the right side of that historical paved roadway. His driveway comes right off of here. His parking pad is up in front of the house. And then there's still a third thing. He has a corner to the back property behind the house that is accessible from that roadway, and that's the only way he can get back into that property, because the testimony was that the land that's left close to the river is so soggy and wet and damp that you can't get trucks and things in that way. So his parking pad would be cut off, as it is, by the fence. That is, the fence posts are there. The fencing is not there. The access to the back property would be cut off. With only a license, he would be able to just get into his driveway and drive around, get to his house, but not get to the back property, and not really be able to use the front door from a vehicle, to drive a vehicle, park it, and then go into the front door. May I address the question of third-party contract?
Go ahead.
All right. The law is clear that third-party contracts, that if I'm a third party, I have to be an intended third-party beneficiary, and both parties in privity have to intend for me to be benefited, or for a class that I'm a part of. And that one case that's old now from the second DCA is with the concurring opinion of Judge White is really Carthage against Soper. It uses the language, easement beneficiaries, talks about people who weren't parties to the original transaction. But the big question here, and the question that was decided adverse to appellants, is did the Colemans in any way allow for or intend for this easement to benefit the class of beneficiaries, adjacent property owners, ingress and egress for adjacent property owners set on their deed. Now, contrary to my friend Mr. Smith, I don't think the law is that the only way you can tell my intent is if I make an express declaration of it. I mean, juries and fact finders determine intent from the facts. And here's the rub. In their reply brief, appellants say, and I quote from page 9, "Every action taken by appellants since the beginning of this saga screams that they had absolutely no intention of benefiting appellee with an easement over their property." Now, if that were correct, we wouldn't be here. It's true that the grantor clearly indicated, and Mr. Troe, his lawyer, did not say, "I thought that." He said, as did the surveyor Wilson, "I did what I did. I prepared the documents. I drew the survey. I made the legal description. I made the sketch with an easement, because that's what my client, Schmutz, told me." So there's no question about the grantor. The question is the grantees, the Colemans. And if, in fact, every action screams that they had no intent, I want to suggest to the court that there are at least 9, and maybe 11 actions that the trial court had before it to consider that showed an acceptance of an easement. There was the title insurance binder with Exhibit A, with the express easement, with the described easement in the legal description.
Now, was the action of the lawyer and the surveyor that they said was consistent with the intent to provide this easement in the context of this explicit agreement to get an easement in exchange for maintaining part of the road?
No, this action was all in connection with the closing with the appellants. And that's what I mean. That closing had a title insurance binder, Exhibit A, contained the easement. It had a sketch and a legal description by Wilson, contained the easement. The deed with the language subject to easements, if any, for ingress, egress for adjacent properties, plus Exhibit A, the easement.
Well, that language on its own wouldn't have any particular effect, right? I mean, that's you can put that standard language in even if there are no easements for ingress or egress, right?
Exactly. That's the whole point. From the American Quicksign case, that language creates an ambiguity. That's why you're looking at all this stuff. And then you've got the surveyor who says, if I were trying to draw something from that, the first thing I'd do when I came to that language is look further. I'd do some more research, and then I'd come to Exhibit A with this meets and bounds description of an easement. That same meets and bounds description was in the mortgage, in the owner-seller's affidavit, in the appellant's buyer's affidavit, in the title insurance policy. And then, on top of that, 2 years later, it's in the survey that they get when they remortgage the property. And it's in the mortgage that they give to Donnell and State Bank when they substitute that mortgage for the original grantor. On top of all that, if those 11 aren't enough, if those 9 aren't enough, then there's a couple more. There's the continuous uninterrupted use by Mr. Evans of the entire easement roadway for over 16 years, since appellants owned it, and for really since 1987 when they built their house. And then the last consideration is when the Colemans first came to look at the property and were considering putting in a contract, they saw the use of the historical roadway easement. And so they knew even back then what they were dealing with in terms of the use of the property. I just want to say that the trial court took into consideration all these facts and the disputed testimony and concluded that the intention was for an easement for adjacent landowners containing that historical paved roadway. And I will close with a quote from 2 cases. One is from this court, Estate of Despain against Avante Group, Inc., 900 Southern 2nd, 637. It is firmly established that trial courts are granted discretion in making decisions because they have a superior advantage to observe what transpired in trial proceedings and to weigh the credibility of the witnesses, their testimony, and the evidence admitted. And then from Wynn against Aside, 163 Southern 2nd, 760, 1st District, 1964, appellate courts do not have the power to substitute their judgment for that of the fact finder below, even if the reviewing court might have reached a different conclusion. That's where we are. The court, after a long day of trial, took into consideration all the documentary evidence, 40 exhibits, all the witnesses, 5, 2 of them twice, and concluded, credited adversely to appellants. The only way that decision could be set aside is if this court were to make different factual determinations than the trial court. Thank you very much.
Thank you, counsel. All right, Appley, you have 2 minutes.
Thank you, Your Honor. Let me just clarify one thing about the fencing aspect of this. This court on several occasions, amongst other courts in Florida, have found that fencing is permitted or can be permitted on an easement. Even gates, electronic gates, can be permitted even with an express easement. So the fence is really not what's at issue here, and the fence was never raised by any of the pleadings. It's our position here that the court, even though correctly found the bulk of the facts and did a great job in writing the court's opinion, applied the wrong legal standard as to third-party beneficiary. That is, the real issue is the intent of both of those parties to that transaction that included the Colemans. What the court said was clear and convincing evidence that Schmutz, the grantor, intended to benefit Evans, maybe so, but only that Coleman was on notice, not that Coleman intended to benefit Evans. That does not follow the legal standard of contracts of third-party beneficiaries as specifically adopted by the American Quicksign case and the Esposito case.
Would the alternative remedy of the license preclude the Evanses from accessing a portion of their lot, as your opposing counsel alleges?
Your Honor, there would be a gate placed, and there is an exhibit, and I will be more than happy to provide the exhibit number that actually shows the layout and where this 50 feet would fall. It would not prevent him from using his driveway. I do not know about the turnaround pad, but it also provides in the license that further down the easement, he could put a gate into the fence that would allow him to access the backside, or I guess it would be the east side of his house. So he would still have access. What he could not do then was have people park along the Coleman's driveway or use this easement down to their house where there is a turnaround for them. There is sufficient room to turn around in the easement itself where you'd have the license. And again, when Mr. Lapierre said something about the Colemans being on notice.
Counselor, your time's up.
Okay, thank you, Your Honor.